going on, everybody? So we have a few minutes before this thing gets started. Just getting everything set up. If you guys can share the stream out. Like I said, we have a few minutes before this starts. Just getting everything set up, shared out. Make sure you share the stream. Today's going to be the closing argument for the John Doe hearing. So it's going to be a short stream. Judge Yamahiro told Kim Motley she had 45 minutes. So, barring any technical difficulties, if they're going to end up showing any exhibits or whatever, this should be relatively short. What's up, Cammy? So we got, like I said, we have a few minutes. Just getting everything shared out, making sure there's no issues on our end. Probably, as long as they start on time, probably probably about 5 minutes. Oh shit. What the fuck is this? Just got a whole shit ton of open records from Waukesha Police Department pertaining to Kenosha. Holy shit. So we'll go through that. Just to give you guys some updates here while we're waiting. Just a lot of fucking records. So we're going to be filing, so obviously you guys know about our lawsuit with Kenosha Police Department. We have until the 28th to respond to their motion to dismiss. They're claiming that I didn't file open records. That's what their motion says, which obviously is a lie. So we're drafting up our response to that and then filing an amended petition for writ of mandamus. So we have like 35 open records requests at this point. The lawsuit only names 13. And then yesterday, we received a response back for quite a few other requests that we put in that are also denied. One of those requests had to do with reports pertaining to the unrest. And in their denial letter, we were told that there were, I think it said something like 619 reports that were generated from the Kenosha unrest. And it would be overly burdensome for them to go through 619 documents to see if they could release it to us. So we filed 12 separate requests for each day. So one request for the 23rd, one request for the 24th, so on and so forth until September 2nd. So it's not overly burdensome for them to go through records day by day, even though they're going to be doing the same amount of work. And then we filed another request that we got back that was denied. It basically asked about their surveillance when it comes to phones and drone surveillance and all that type of stuff. That request was denied for being overly burdensome. I think there was like 300 and, I don't know, 300 and some odd amount of documents or records. They said it was overly burdensome, so we filed 12 more pertaining to that because we want all that. So we're up to 59 open records requests at this point with Kenosha Police Department. They released call sheets to us, which their call sheets are basically every Karen that called about some type of incident that was going on in Kenosha. So we got that, everything except August 25th. So we refiled to get those. Not generally something that we release to the public because it does have every Karen's name on it that made a complaint call. So now we know all the Karens in Kenosha. But yeah, that's the only thing that was released. So we refiled for the August 25th for their call sheets. So that'll be open records request number 60. So we're filing an amended petition now for all of those requests. We'll go through the Waukesha open records and see what we have. I just got the email as we were getting this set up, so I haven't even looked at it yet. How's the sound? Microphone sound okay? It's not weird. Release a Karen video. I'll tell you what, there's a lot of Karens in Kenosha that called over suspicious activity. So there's like over 100 pages. Well, we're still waiting for them to start this. So as soon as they do, then I'll flip this camera around so you guys don't have to see my ugly face. I will tell you guys that today is probably going to be our last stream. There we go.
It says that, but it always says it's streaming afterwards, so. Right, you Mr. Williams?
Yes.
All right, we're gonna call the case.
State of Wisconsin versus Leland Williams, 21 CF 706 appearances.
Anthony Jackson on behalf of the state.
Looks like they're running late. So we're not going to show this poor guy. Yeah, anyway, so the short of this. Oh, now they want to fucking charge me money. The short of it is that we haven't paid the Airbnb in the last 3 weeks, And they have somebody renting it tomorrow morning. And they're trying to move me over to the unit next door, but only if I have money. So we need to come up with as much money as humanly possible. Otherwise, I lose my roof. And if I lose my roof, Never.Stop Media is fucking indefinitely shut down. So that is where we're at. Ideally, we need to raise $1,200, and we have until the end of today to do that. But we need to get as close to that as humanly possible so we can give them something so that I can move over to the next unit and continue what we're doing. Otherwise, that affects everything. We have 2 more videos to release from the courthouse cameras for August 25th. And then we need to start on the 15 videos for August 24th. So if we lose the roof, we can't do that. We lose the roof, that affects this lawsuit. And then the shitty part is that we're a couple months behind on the storage unit that has all my property, which means I have no place to put any of this stuff. And I can't even get my camping shit to go hammock stealth camping. So we're pretty fucked. So there's some links down there in the pinned comment if you guys want to help. Otherwise, poor little Kevin is homeless and Never.Stop Media is fucking shut down.
Hi, members of the gallery, good morning.
All right, here we go.
I'm going to call the Mensah case shortly. A couple reminders, no cell phone use in the courtroom. Need to use it, step out. I don't care if you're journalists or regular citizens.
Can you guys hear?
Use of cell phones in the courtroom may subject them to confiscation. There is no photography, there's no recording. There will not be a decision today, FYI.
We
I'm
figured.
looking at a possible date of June 25,
Jesus.
subject to room availability. I do plan on getting this in for decision in the month of June. And so that's basically it for today. I'll just ask everyone to maintain the same decorum that's been displayed over the past several hearings. That is appreciated, and we should be all set in a couple minutes.
No, Erica, it's so we were paying $1,200 for the month. The unit next door is smaller, so it's a little cheaper. But like I said, we haven't paid for the last 3 weeks.
Okay.
They've been super cool because they are friendly to the movement.
Yeah, you can. Although you may want to be mindful of, you know, if you want.
So they've been working with me.
Square off, so.
So we've been like any donations that have been coming through Venmo and whatever, $25, $50, whatever, we've been sending it over. But I haven't made any type of payment in the last 3 weeks. So the unit next door is going to be a more permanent situation as long as we can fucking keep making payments. So, and like I said, I mean, without a roof, I can't do shit. I can't upload videos. I can't do anything. We'll be standing on a fucking sidewalk.
Is somebody in here that?
I'll turn the volume up when they start. They're kind of chit-chatting. So today is going to be their closing argument. And then you just heard the judge. He'll have a decision about this sometime next month.
So it looks like June 25th is open, but it won't be open in this courtroom. It'll be open in room G55 of the CJF. So we're going to try and reserve that space now.
Thank you. You said at 9 o'clock?
Yes.
Yeah.
Thank you.
All set?
Okay.
All set?
Just one more minute, Your Honor.
All right.
All right, so June 25th, 9 a.m.
I have
The
to zoom in
decision.
real quick.
All right, for those of you that just came in, there's no cell phone use in the courtroom. You need to use your phone, step out.
Make sure you guys share the stream out. It's a big day. So I did have one of the August 25th courthouse videos that should have been ready to upload to YouTube this morning. But while I was sleeping, my computer crashed.
It's your computer. You'll need to.
Turn your sound down.
I have it turned.
Can you mute your?
Is that better? Okay, sorry.
All right, here we go.
All set?
Yes.
Okay. Ready, sir? 20 JD 15 in Ray 968.02 sub 3 complaint. Appearances.
Attorney Kim Motley appears on behalf of the petitioners, Linda and Jay Anderson and Starkeisha De La Rosa. Good morning.
Good morning. You're on mute for the Zoom, it looks like.
No, dude, we can hear.
So she should stay muted there?
Yes, your computer will stay
Okay.
muted, but she'll be heard through the mic.
Okay. Okay, go ahead.
His name was Jay Anderson Jr. He was the eldest son to Linda and Jay Anderson, who have 2 other children. He was engaged to Starkeisha De La Rosa, and they have a beautiful daughter, Jalen Anderson, who just turned 6 years old. He was a hard worker. He worked as a cook at Ruby Tuesday, and he often helped his father with landscaping jobs. He's affectionately known by his family and friends as Baby Jay, including friends like Hakeem Fudge. And he was 25 years old when he died. For 5 years, nearly 5 years, Joseph Mensah has shaped the narrative of what happened on June 23rd, 2016. This narrative was shaped by a 47-minute, unrecorded conference room conversation that occurred at the Wauwatosa Police Department. Now it's time to listen to the most important witness in this whole situation, which is Jay Anderson Jr. For almost 5 years, we've heard stories about what happened on June 23rd, 2016. And based on the investigation that was conducted by the Milwaukee investigative team, we realize now that it wasn't an investigation, but it was all about justification. We believe that there is probable cause to criminally charge Joseph Mensah. We agree with Dr. Tolomac that this was a homicide. We believe that homicide that was committed was second-degree reckless homicide. And we also believe that Joseph Mensah should be charged with homicide by the negligent handling of a dangerous weapon. And we ask the court to find probable cause to charge him with both offenses. In November 1984, D. Thorne Graham, who was a diabetic, went to a gas station with his friend. He was having an insulin reaction and he wanted to drink some orange juice right away. So his friend drove to the gas station and D. Thorne Graham ran out of his car. And when he ran into the gas station, he saw that there was a long line. Because he didn't want to wait in line, he ran back out in the car. And there was an officer, Officer Connor, who saw this happening and decided to follow the 2 men. Less than a mile away, he decided to stop these 2 men. And Officer Connor basically told them, didn't believe what Mr. Graham had to say, and ordered him out of the car. Mr. Graham ran around the car twice and eventually passed out. Officer Connor called for backup, and Mr. Graham's friend pleaded with the officers and said he's a diabetic. He asked him to look in his pocket for his diabetic card, but the officers refused to do that. Instead, what they did is they handcuffed Mr. Graham and they slammed him on the hood of their car. Once they verified with the gas station that nothing had been stolen and that Mr. Graham had not engaged in any criminal activity, they actually uncuffed him and took him home. Based on that encounter, Mr. Graham walked away, or should I say limped away, with a broken foot and multiple injuries. It's because of that situation in 1984 that we received 490 U.S. 386 Graham v. Connor, which was ironically decided by the Supreme Court almost 5 years later, just like we're here almost 5 years after the incident involving Jay Anderson. And what the court decided in that situation is that in order to determine where the use of force was reasonable, that there should be an objectively reasonable test. And basically what this test says is that under the Fourth Amendment, what a court needs to decide is whether the officer's actions are objectively reasonable in light of the facts and circumstances that are confronting them at that point in time. What an objectively reasonable officer would do under a similar situation. This court heard from William Harmony. William Harmony was one of the several expert law enforcement witnesses that we brought before the court. He's been in law enforcement for 37 years, has fired his weapon 0 times while under the line of duty, and he's never had any fatalities. He talked about the three factors that Graham v. Connor outlined when you're determining whether an objectively reasonable officer acted within the color of law in the use of force. He said, first, you need to consider the severity of the crime at issue. Second, whether the subject poses an immediate threat to the safety of the officer. And third, whether the subject is actively resisting or attempting to evade. In this situation involving Jay Anderson Jr., he was not committing any crimes when he was in Madison Park on June 23rd. He was sleeping. The most that Jay Anderson Jr. would have been looking at is an ordinance violation. Wisconsin is an open carry state, which means that Jay Anderson is legally allowed to carry a weapon. And when Officer Mensah approached him, he had no idea whether or not that weapon was legal or not. So the most that Jay Anderson was looking at is no more than a $200 ordinance fine. Mensah told Luke O'Day that he has routinely gone to Madison Park and he's never given anyone a citation. So it's unusual that he would approach Jay Anderson and just automatically assume that he had committed a crime. The second point with the Graham v. Connor calculus is whether the subject poses an immediate threat. Jay Anderson was sleeping. He was woken up by Mensah. He did not pose a threat to Mensah. The third calculus is whether Jay was actively resisting or attempting to evade, which he wasn't. We saw him sitting in the car. We saw him complying while he was sitting in the car. Now, in determining how or whether or not Mensah should be charged, there's several factors that need to be also taken into consideration, such as his training and also his experience as an officer is also something that should be considered. We heard from his boss, Chief Weber, who testified that he's been in law enforcement for 37 years and he has never fired his weapon. For 31 of those years, he's been the chief of police for the Wauwatosa Police Department. And he actually sat in the witness chair and tried to pretend like they had a fitness for duty policy. Begrudgingly, he ultimately admitted that the Wauwatosa Police Department does not have a fitness for duty policy. He admitted that after the Antonio Gonzalez shooting, to which Officer Mensah was the main officer who was involved in that incident, who was killed July 2015, that after that situation, that Officer Mensah had not been evaluated by a psychologist. He tried to explain to the court how he got this random call from a social worker who told him it was cool for Officer Mensah to go back to work, but ultimately he didn't follow any fitness for duty standards. In addition to this, we know that after the Alvin Cole shooting that happened in February 2020, based on Weber's testimony, and by the way, Weber said that he's a lifetime member of the International Association of Police Chiefs, which they actually have a fitness for duty standard. But for whatever reason, Chief Weber says that they think they know it all, and that's not a standard that he should follow. And so he thinks it's better to follow no standard than a standard that exists. We know that after the Jay Anderson shooting, that again, there was no fitness for duty policy. And this is really important because William Harmony testified that when you're trying to determine the reason for the fitness for duties policy is because you want to make sure that the officer is safe to go back to work. But frankly, even more importantly, you want to make sure that the public is safe for that officer to go back to work. And Harmony talked about how very important it is to have a fitness for duty policy because it's a specific type of evaluation and it's fairly complex. Usually you do it within 1 week, 3 months, and 6 months after the incident before you decide whether or not it's okay to put someone on the street and whether or not that person should continue to be out on the street. And we know that Wauwatosa did not have that. We also heard from Mr. Trainum, Mr. James Trainum, who's been in law enforcement for 27 years, has fired his weapon 0 times while under the line of duty. He talked about officer-created jeopardy. And what officer-created jeopardy is basically where you look at the totality of situations and did that officer put themselves in a situation to use force? And was that force justified? He believed that based on the fact that Joseph Mensah was standing what he called in the kill zone when he interacted with Jay, that was officer-created jeopardy. He talked about the way that Officer Mensah parked his car in front of Jay Anderson, which, by the way, it was important for the district attorney's office to review Mensah's training, to review policies, procedures. They never did that. They never did that for almost 5 years. We know that they didn't even bother to talk to Chief Weber until after they made their decision. But that is something that under Graham v. Connor that they should have considered in making their decision that they failed to do. We know that according to we also know that according to Joseph Mensah's testimony that he wasn't in his patrol area. So what I'd like to do, if it's okay, but I'd like to share my screen.
And I think we could actually turn that monitor towards the gallery so they could see something besides your back during this. I don't need 3 screens. Gonna help her out.
Okay. So I think I have to be made as a host.
Okay. Let's see. Oh, okay.
Am I good?
Almost. Okay.
Thank you. There's CJF 4th floor. Should I admit that person?
No.
Okay.
I'll retain control over the admitting of people into the Zoom.
Sorry.
Yep.
Can you see my screen?
I just see you. You calling over to CJF, Deb? Okay, he's gonna get that off the screen.
Okay.
Are you able to,
my PowerPoint is showing here, but is it showing on yours?
no.
And also, Your Honor, you have a hard copy of all this stuff, just so you know.
That's fine.
Let's try it again. Maybe I didn't, hold on, sorry, let me go back. Share screen. Okay, here we go.
Okay. I don't know why we're getting this piece here. See this white on the right side there? And how we'll get rid of that. Do you have your screen on full?
Yeah,
I don't know what that white block is there.
yeah, this is not even what my screen looks like. I have hold on. Let me close out again.
That's better.
Okay, so let's try that again. I think you just gotta wait a minute because all right, it's coming. I don't know why it's.
So when this is when this is done, I'll end the stream and then I'm gonna come back. We'll look at
Do you see my screen?
some
I have my
Waukesha
PowerPoint.
records that were sent, and And then the U.S.
I see
Marshals.
what's on the TV monitor in front of me. I don't know. I can't see the other one, so.
U.S. Marshals just sent me something that was very interesting.
I mean, your whole PowerPoint was showing a moment ago, and then whatever you clicked on created that white space, so.
All right, let's try this one more time. If it doesn't work, we'll just have to go old school. Let's stop share. I'll just start the whole thing over again. Start share. Oh, slideshow.
Well, like I said, I haven't looked at the Waukesha Police Department records yet, so we'll look at that stuff together. But this U.S. Marshal letter is rather intriguing. Reading it on my phone right now. The U.S. Marshal letter is pertaining to the 2 articles we wrote on a 4th shooting victim.
Let me see. Or something. My screen is different than this screen.
Okay.
It's very important. Is Miss Wolf by any chance calling IT?
Not that I know of. You want her to?
Yes, please. Sorry. I stayed up all night doing this. We're gonna want to look at these slides.
So if you guys are just tuning in, we are on the closing argument for the John Doe hearing. If you're watching this through a restream, you're actually watching Never Stop Media, so just come to the source. Stop watching it through a restream.
You see the message?
Yeah, it's a really interesting letter, April.
We are entering 6:35. It's something to do with, device is trying to screen share and show it on the laptop.
No, I think it's
Because thank you.
Is he coming over? All right, he's coming over.
no problem. My closing, just so you know, will take no more than 37 more minutes. Promise.
Here till 12.
Of me talking, not, this doesn't count. This time doesn't count. Okay.
Oh, Jesus. All right, well, while they're screwing around with that. With KPD, we're now dealing with a totally different records person. I just got an email from them too. Shit cracks me up. Now, what they're doing is so all of my open records requests now go to the second person, but they're all also going to their attorney, or two attorneys now. They've brought in a second attorney to battle little old me. So they're sending it to the second officer and then the attorney to have reasonable objectivity in looking at my requests, so that when they get denied, they can be like, oh, well, we even sent it to a second person. But in one of our requests, this email is talking about he wants a little bit more clarity, which is not required by them. It's up to the records custodian if they want to do that. So typically, if they're not dickheads, then they'll be like, hey, we were a little confused on blah, blah, blah. Can you clarify a bit? Which we get a lot with other records custodians in different departments. No, it's adding to another job where we were told that KPD themselves doesn't charge for open records, but if they have to bring in a third-party company to search for stuff, there's a fee for that. But because of the amount of requests that are coming in, that KPD is going to start charging for records. And potentially bring in more people.
Yeah, thank you. That's it. Yeah. Let me just play with it while I'm sitting here. Let me see. Share screen. Share. Why does he keep doing that? You know it's gonna be something stupid too. Let's see.
Oh, Christ.
It does it like when I get out.
So if you guys are just tuning in, they're having some tech issues.
Yeah, look,
We're
slideshow.
waiting for them. There, it's fixed.
Play.
It's fixed.
Oops.
But we're waiting for them to fix this.
Right, because look. Your Honor, maybe I'm the host now on this. Wait.
Holy shit.
Yeah, it seems to see the same thing. Okay, maybe we're making progress. Let's see. Slash play.
Oh, that one says
When I exit out,
6 seconds.
what did he do last time? Okay.
Good morning.
Good morning.
What seems to be your issue?
Well,
You know, it's funny reading these text messages between these different law enforcement officers regarding Kenosha. Like all the text messages that we've seen so far, they
So you're plugged directly into.
they're all like irritated with
so
Kenosha.
that is from my computer.
Like one of these, I'll just read you one text. It says,
All shined up, it looked like this. I had a couple pair that I think I resold two or three
I
times.
don't know on that one.
it says these
I don't know, maybe.
These
if I
fucking
take this
idiots
out,
are doing a smart
no.
call from 2 counties away and are only going to take 12 members. Seems
A version of
wise.
my screen, but not this.
Like there's
Let's see.
a couple cops in here like texting, talking shit about Kenosha.
Yeah.
It's funny.
What was that? Oh, thank you.
Then there's a text. So it names these 2 officers and it says forgot their masks, had to find extras in the squad. I don't know if said officer filter isn't good.
But it doesn't make any sense because it's showing like.
The other guy
my
says
stuff. You know
classic,
what I mean?
I've been feeling lonely. You haven't called me in a while.
and then the other cop says hold your breath and close your eyes, kid.
Doesn't
At
make
least they have a sense of humor.
I can just.
The bench sees what's on the TV. So, I'm not sure what's going on.
They're like sending memes to each other and shit.
The bench is seeing the same thing that's on the TV. So, I always have to itself.
Because it's worked here before. So.
I don't have a solution for you.
Trying to see if there's anything juicy. I got videos.
Like I said, right, instead of putting it on Zoom, just having it for report.
Oh
When you're
shit.
connected to the HMI cord now, you're going into the network, whatever is on your computer should be coming up on the screen, which is odd because your screen is blank and.
No, but what if I get out of Zoom
Yeah.
and just share my computer?
Yeah. See, the screen share thing is up, on about that before, so why don't you do that?
Okay. So I'll get out of
Again, if you guys are just tuning in, they're having tech issues.
Zoom.
So we're waiting them to figure it out.
Sorry, trying
No problem.
to get
No
out.
problem.
Yes. Yes.
Stop sharing. So now I just have my HDMI. How can I share it with just my HDMI?
All right, so that would be on the bench then.
Yeah, but you don't have to. You better hurry up. Oh, okay. Yeah, I think I'm just not gonna be on.
Oh, yeah.
Now you seen that on the screen?
Well,
There you go.
let's see, slideshow, play from start.
See if we can play this.
Yes. Now it's working.
Okay.
I don't know what. How do you do this where it doesn't show?
Holy shit. We got drone footage.
Just, and then once you go back to speaking, I'm gonna take that and check.
It's basically
Okay. Thank you.
same stuff that we're releasing from the courthouse cameras.
Right, no screen share, just the evidence button.
So I'm like looking at the 24th.
So you're on, I'll get back.
So we
to
haven't
you,
released-
But I won't screen share.
The 24th yet.
Okay.
Sorry.
This is a drone video. Interesting.
Only for
That's fine. 37 minutes.
Yep.
Okay.
Thanks, Mike.
I think we're ready
Thank
now,
you. Sorry
finally.
about that, Your Honor.
Right, we all set?
Yes.
All right, here we go. We're back.
So we know that Mensah was outside his patrol area that night. According to his interview with Luke O'Day, he told him that his patrol area was actually from 92nd Street to Burleigh, from Burleigh to 124th Street, and that to Capitol. We know that Madison Park, which is circled here, was outside of his patrol area that night, and Mensah claimed he went there twice. Now, as it relates to how Mensah, why was he there? He said he was there for a routine part check, and he actually did an interview on July 28, 2020 with Dan O'Donnell, and this is just a short clip from it. This is Exhibit 22 for the record, page 17, lines 15 through 25, and page 18, line 1.
Explain what the weapon fired that weapon in every single one of them, and out of all of them. The entire, they're suspecting all these incidents to the eye of the problem in every single one of them. Because we don't take up the fact that you have people that are committing crimes, or I'm going to call people have committed crimes, they present a weapon. up in the officer's fault.
According to this interview,
Excuse me, I'm going to ask you to read that portion of the record because
No
it's a little
problem.
hard to understand over the.
no problem. So what Mensah said on July 28th is that either they displayed a weapon, went for a weapon, fired that weapon in every single one of them. And out of all these, their defense in all these incidents is that I am the problem in every single one of them. It completely takes out the fact that you have people who are committing crimes, where I'm going to calls where people have committed crimes. They present a weapon at an officer, the incident unfolds the way it does, and it's the officer's fault. How? He was not going to Madison Park because he was called to be there. Jay Anderson had not committed any crimes while he was at Madison Park. We heard from Sergeant Pamela Holmes and also Detective Ricky Burns. And we see in this picture that there's Joseph Mensah's car, that is the SUV with the takedown lights on, facing Jay Anderson's car on the night of the early morning hours of June 23rd. We know from Sergeant
Right,
Pamela Holmes.
The record should reflect that you just showed Exhibit 73, I believe.
I'm sorry.
Okay.
And for the record, I'm showing Exhibit 70, and we'll show several pages of Exhibit 70. We had Sergeant Pamela Holmes, who actually testified about the fatal funnel position. And what the fatal funnel position, which is a position where the officer should not be, because officer safety is the most important thing that an officer needs to worry about. She also testified that traffic stops are the most dangerous thing that officers routinely do. The fatal funnel position is what's from the driver's side door to the front of the car to the passenger side door. That area is determined to be the fatal funnel position. And the way that Mensah faced his car and parked his car on June 23rd is contrary to the way that he has been trained to park his car as a Wauwatosa police officer. Through a subpoena, we received all the vehicle contacts training of the Wauwatosa Police Department from May 2016 to present. And in 5 years of training records that we have, never, ever do you see the car parked parked in front of a suspect, as Mensah inappropriately did when he parked in front of Jay's car. And we know that at some point that Mensah was actually behind Jay's car because Jay didn't have a front license plate. He only had a back license plate. What Mensah should have did, according to his training and according to all the officers who testified, is once he was back there and ran Jay's plate, he should have stayed back there, because that is what is consistent with his training. We talked about how, with regards to the equipment, at the scene, Mensah claims that his equipment didn't work. And we know that with regards to traffic stops, that he's required per Exhibit 44, the in-squad video policy, that when there's a traffic stop, you're supposed to turn on your wireless microphone to catch the audio. He didn't do that. We know for traffic stops, he's supposed to put on his red and blue lights, and that automatically enacts the squad video. He didn't do that either. And we know that he didn't do that. But for some reason, after he shot and killed Jay Anderson, his squad vehicle video miraculously started working. And on July 28th, Mensah did a radio interview. We're going to play a short clip here. And in this interview, what we're playing is Exhibit 22 and lines, page 24, Exhibit 22, page 24, lines 22 through 25, and page 25, line 1. So let me read this for the record. What he said is, let's talk about 2016, for example. There's my account of what happened, but there's so much other evidence involved with that case. Evidence I knew nothing about. The family claims that I violated a policy by not turning on my squad cam. I'm not going to get into it, but at the same, that's not a policy violation because there's reasons and circumstances when that gets turned on. But it was turned on because I turned it on. You can't accidentally bump that camera. You can't accidentally push the button. It's in a leather case. You have to physically turn that button on. I turned it on. I turned it on because, yeah, I knew that people would want to believe me, but I wanted them. I needed them to. I needed them to have that evidence to support what I saw. So I turned that on, fully knowing that once I hit that button, it would go back in time, or it would go back, 20 to 30 seconds, and it would capture that. I did that, end quote. What Mensah did is he turned on his squad camera after he shot and killed Jay Anderson. What Mensah did is he failed to turn on his audio recording, and we have no idea what they were talking about. What Mensah did is he failed to turn on his red and blue lights that inactive his squad camera. That's what he did. We also know that when Mensah was at the crime scene, he had shot and killed Antonio Gonzalez 11 months prior to shooting and killing Jay Anderson on June 20, 2016. While he was at the scene, he was talking to Lieutenant Gabrish, who was a Wauwatosa police officer, and can be found in Exhibit 59. And while he's at the scene, he's seeing things like, yeah, I have to give them all this stuff at the station. He's explaining familiarity with the process of what happens after a police shooting. We know when he approached Jay Anderson, he only turned on his white takedown lights. And this shooting happened at about 3:07 a.m. We know that the Milwaukee investigative team took over this investigation at 3:59 a.m. And when they took it over, we know that for some reason, Mensah's squad white lights had been turned off and someone had turned on his red and blue lights. But we have no explanation as to who did that. The only person that should have access to his car between that time period is Mensah. And that's also a violation of policy. We know that Mensah claims that he interacted with two people at Madison Park at 12:30 a.m., but there's no evidence to support that. He claimed that when he interacted with these two cars that he turned on his red and blue lights, which would have engaged his squad video. That was never verified. According to his story, he actually talked to a person and they left the park. Both cars left the park. But he never wrote a report about it. There was no video about it. That wasn't on Madison Elementary School video that captured him doing that. We also know when we listened to William Harmony, he talked about excessive force. And he talked about that he was our use of force expert. And he basically said that we don't have a lot of questions answered. We don't know why Mensah unholstered his weapon. We don't know why he really pointed his weapon. We don't know. We have a lot of unanswered questions. He doesn't remember when he pointed his weapon at Jay. He doesn't remember if Jay Anderson ever took possession of his weapon, but it was not a justified use of force. Pointing your weapon at someone, according to Mr. Harmony, is use of force. And obviously, shooting your weapon is also use of force. The actions of Mensah, he testified, were objectively unreasonable. They were unreasonable and disproportionate to the situation that he was in. And also, we don't know, and Mr. Harmony asked a good question. What was the difference between the fourth time when Jay Anderson supposedly put his hands down? There is no difference between that, the first time, to the fourth time. Why at that point in time did Mensah feel emboldened to fire his weapon? We know that Wisconsin Jury Instruction 885, they give privilege to use of force. And basically, again, we're talking about whether Mensah's actions or beliefs were reasonable. The standard is when an ordinary, prudent, and reasonably intelligent officer would have believed in Mensah's position, having the knowledge and training that he possessed at that point in time and acting on the circumstances that existed at the time of the offense. We believe that Mensah's actions were contrary to his privilege for use of force. Also, we believe that Jay was never a threat to Mensah. And according to Wisconsin Statute 939.48, which is a self-defense statute, that Mensah was not privileged to use self-defense. Jay was no threat to him. He never presented to Mensah that he was going to shoot him or that he was in great bodily harm to any actions of Jay Anderson. We also talk about...
Excuse me, do you want to put yourself back on the Zoom or not?
No, because I'm going to keep this
Okay.
up if that's okay.
All
But
right.
I will. I thought I am back on Zoom.
Well, but in terms of the live stream, I don't think anybody sees you, so that's why I'm bringing it up. They're just seeing the...
Okay, sorry. I thought it was... would you like me to do that?
It doesn't matter to me. I mean, I see everything. But
Okay.
if you have extended periods where you're not going to use your Zoom with your PowerPoint, I just thought it might be good for you to get back on the video if you want.
Okay, I will after this done. And to be honest, Your Honor, you're the decision maker. You're the one that needs to see this. It's nice to have everyone else see it, but this is for you. So with regards to Detective Ricky Burhams, he testified. He's a law enforcement officer of 32 years. He's fired his weapon 0 times while under the line of duty. And he talked about the totality of circumstances. He has investigated hundreds of homicide investigations, as has James Trainum. And he talked about the scene, the wounds, everything. And what we know from Ricky Burhams, Detective Burhams' testimony is that Jay Anderson Jr. is the most important witness in this whole situation. And what we're going to do is we're going to play slide 22, the audio dispatch call. And I'm going to have Mr. O help us with this portion of our argument.
I'm sorry, drinking. From the station. Native 2006 Nissan Altima silver in color to Elena De La Rosa, 4520 North 110th Street, current.
I'm stepping up here because.
All squads respond to Madison Park. All squads respond Madison Park. 370, did you copy?
I did not, sorry, go ahead.
305 is out with the subject at Madison Park with a firearm.
Yeah, multiple squads going on the release of prisoner.
Affirmative, everybody's on.
Shot fire! Shot fire!
We know that Jay Anderson.
You may want to use a microphone. You could use that one on the table there.
Okay. We know that Jay Anderson and Joseph Mensah were in the park for 4 minutes and 50 seconds alone. What were they talking about? The only thing that Mensah said that their conversation is he asked twice for Jay Anderson's ID. He says at some point that he told Jay to don't do it, don't do it. Well, that's about a 15-second conversation. What was Baby Jay talking about for the rest of the 4 minutes and 30-odd seconds of a conversation? Did Joseph Mensah ask for his name? Did he ask why he's there? Did he ask, is this gun registered? The only thing that he said he asked for was Jay Anderson's ID twice. And we know that Jay had his ID on him because he was hanging out with Hakeem Fudge earlier that night. We know Jay had his ID because a Wauwatosa police officer found his ID. We'll talk about that a little bit later. And we know that for whatever reason, Mensah felt that Baby Jay was a threat that night. What were they talking about? The Milwaukee investigative team never pressed them on this. For 4 minutes and 50 seconds, they were together in that park. That silence speaks volumes to what happened in Madison Park. We also know, according to what happened at Madison Park, that for 19 seconds, Joseph Mensah, for a minimum of 19 seconds, was pointing his weapon at Jay Anderson. We know that because that's how the video began. 1 1,000, 2 1,000, 3 1,000, 4 1,000, 5 1,000, 6 1,000, 7 1,000, 8 1,000, 9 1,000, 10 1,000, 11 1,000, 12 1,000, 13 1,000, 14 1,000, 15 1,000, 16 1,000, 17 1,000, 18 1,000, 19 1,000. Detective Burns said that he was locked and loaded for 19 seconds at a minimum, pointing his weapon at Jay Anderson while he was sitting in his car, while he was sitting there being woken up after he had been sleeping. Detective Burns talked about target acquisition, which is basically he was aiming for his target for those 19 seconds. And we know that that's a very, very long time. Joseph Mensah taking his weapon out and pointing it at Jay Anderson for those 19 seconds was an inappropriate use of force. Jay Anderson was not posing a threat to him at all. For 19 seconds, he did that. What was Baby Jay saying to him? He had Jay in his sights that whole time. We also know, with regards to what Detective Burns also testified to, he talked about the wounds that were on Baby Jay. And out of respect for the families and the courts, we're not going to show any photos, autopsy photos of Jay today. But this is taken from the autopsy report of Dr. Talomac. And we know that based on the wounds, that wound number 1, she said, was ear to ear, right to left, with no deviation. If Jay had been lunging for his weapon, lunging his body, as Mensah claimed he had been doing, there would have been some bullet wounds here in the upper part of the area. In addition to that, we know with bullet wounds that were on the top of Jay Anderson's head, above his ear. Again, Dr. Talomac said right to left, with no upward, downward deviation. Again, that's inconsistent with lunging for something on the passenger seat. We also know that there was a bullet wound that was right under Jay Anderson's eye, and there was a bullet wound to his right shoulder in the back. Again, inconsistent with lunging for anything in the passenger seat. Another story that I think these bullet wounds show is that it again shows what a great witness Jay Anderson Jr. is. It shows that clearly he was facing forward when he was being shot. And that if you think about it, he wasn't challenging Mensah, who was shooting at him. He wasn't looking him in the eye. To me, it shows that he was being deferential, that he was complying, that he was cooperating. We know that in terms of all the cooperation that Jay Anderson did that day, that he was woken up by Mensah. Jay Anderson complied with that. We know that Mensah asked Jay Anderson to roll down his window. So Jay Anderson put the keys in ignition, turned the car on, and rolled down the window. That's compliance. We know that Officer Mensah asked Jay Anderson questions. He claimed he asked him twice whether he had his ID, and that Jay said no. Answering those questions, that's compliance. We know that Jay Anderson had his hands up. He didn't do it on his own. He was ordered to do that by Mensah. That also is compliant. And frankly, these wounds also show compliance and deference of Jay Anderson Jr. that day. Detective Burns also talked about that once you're shot in the head, that essentially all your motor skills stop. And that once you pull the trigger, that bullet is instantaneous. So wherever Jay was, he would have dropped immediately. And he did drop. He was shot while he was looking face forward in the driver's seat and and that's where he dropped at, in the driver's seat. He never was lunging towards anything in the passenger side. That's nonsense. And the Milwaukee investigative team, they never bothered to check up on that, to see if there's any validity with that. We also know that based on what Ricky Burns testified, that there would be some blowback. And we also have bullet strike number 5, which again was to the headrest and to the back of the headrest. And this bullet presumably shattered that back window. If you think about the bullet wounds to Jay Anderson, it's almost like a bullseye, right? Shot upper ear, by the eye, back shoulder, right shoulder, headrest. It's like a bullseye. It's what Detective Ricky Burns talked about grouping. He grouped his shots in the head area. If he was lunging, none of those shots would have happened in that area. It wouldn't make sense. We also know from Ricky Burns that he said that a bullet is like an explosion. It's not just about what exits, but it's also there is some blowback from the entrance of the shot. And there was nothing on top of the middle console or on the passenger seat. We know that the Wauwatosa Police Department officers, they went to the car, and this is a short video of them opening the driver's side door.
This is Exhibit 32.
What Exhibit 32 shows us is that they opened the car and they stepped back. They were nowhere near looking at what was on the passenger side. They were only focused on the driver's side. And when they opened the door, Jay slightly fell out. And that's what it shows. We also know that based on the evidence that there was that white piece of paper on the passenger side floor, as well as the white cell phone and the money. And there's no blowback on that. There's no blood splatter. There was a scene officer that was there noting different points at the scene, and he didn't note any type of blood splatter or anything on the piece of paper or the white cell phone or also the money. We also know that there was significant interference of the Wauwatosa Police Department with this investigation. We know that Luke O'Day failed to corroborate any of Mensah's story, that he actually went to Madison Park earlier that day. We know that we asked for, when we subpoenaed the Wauwatosa Police Department, we asked for Mensah's entire squad video from 11 p.m. to 7:24 a.m., which was his entire shift. We received about 6 minutes of squad video from 3:06 a.m. to about 3:12 a.m., and that's it. I don't even know if the other squad video of Mensah's exists anymore. But we didn't even get that. We know that we never got that the Milwaukee Investigating Unit never asked for his personnel file. We know that this is Exhibit 32, where we can see the officers taking something out of the front passenger seat, some evidence. We don't really know what that is. They claim that that was the gun, but who knows what that was. But that was Officer Mills who took that. And we know that Officer Mills was only interviewed at the scene. The Milwaukee Investigative Unit, they never bothered to ask him to come in to talk to them.
Right, that's Exhibit 32.
Yes, Exhibit 42. Oh, sorry, Exhibit 32, yes. We know that Exhibit 39, which is Jay Anderson's ID, that this was recovered by Wauwatosa Officer Salyers. And basically, Salyers told a Milwaukee police officer on page 18 that he went specifically digging through Jay Anderson's pockets to try to find ID. And he found marijuana and a cell phone and a bunch of money, like $846 worth of money. But he cannot remember where he found Jay Anderson's ID. It's important to note that he never said he found his ID in his pocket. He told Officer Troy Porter on page 18 that Salyers informed him that he did check Anderson's pants pocket to get him identified.
Page 18 of what exhibit?
Page 18 of Exhibit 39, or sorry, of Exhibit 47 of the police, hold on, Exhibit 42, sorry, Exhibit 42, page 1819. And we know that he doesn't remember when he found the ID. We know that the Wauwatosa Police Department was also allowed to go to Madison Elementary School and get that video that they turned over to the Milwaukee Police Department, which they evaluated about a month later. We know that the Wauwatosa Police Department evaluated that video that same day on June 23rd and gave their evaluation to the Milwaukee Police Department. And instead of them independently reviewing that video on their own, they took Wauwatosa police officers, what they wrote, and said, yeah, we agree with that. And that's it. Because this never was about an investigation. It was all about justification. We know that Lieutenant Roy, who testified that he's been on the force for 20 years and fired his weapon 0 times in the line of duty, that he wrote an 8-page report and that he went and talked to potential witnesses around the area. And he did this on his own. He doesn't know if he wasn't told by the Milwaukee investigative team to do that. He was told by his supervisor at the Wauwatosa Police Department to do that. We know that Mensah gave various inconsistent statements. He said that he had no idea, according to Exhibit 58, he had no idea if anyone was in the park. We know that when he parked his car and approached Jay Anderson in face-to-face, that was inconsistent with his training, that when he got out of his car, he left his car driver's side door wide open, the car running with his long gun in the car, and went and approached Jay Anderson. But he's clueless if anyone was in the park. That doesn't make sense. We know that he said, according to Exhibit 58, page 3, that as soon as he woke Jay up, he put his hands up. The next day when he was questioned by Luke O'Day and where he was questioned at the Wauwatosa Police Department in a conference room where they didn't bother to record it, they didn't bother to ask him to record it. And he told Luke O'Day that Jay Anderson was fake sleeping. We know that on Exhibit 58, at the scene, he told Lieutenant Gavrich that that Jay was reaching for the gun, then lunged for it. The next day, with Luke O'Day, Exhibit 59, he said he was lunging for the gun. We know that at the scene, Exhibit 58, that Mensah said that Jay Anderson was coherent in everything. But we know that Jay was incapacitated, that he was woken up at 3:06 a.m. by Officer Mensah. Jay had a 0.11 blood alcohol content. We know that from Dr. Talomak's testimony. We know that at the scene, Mensah told 2 separate Wauwatosa officers that his recording didn't work. He first told Lieutenant Gavrich, this is Exhibit 58, that he tried to hit his button a couple times. Well, then Lieutenant Gavrich told him to stay with Officer Wade, and then he told Officer Wade that same mess of a story and said that his button didn't work. Well, we know the next day, according to Exhibit 59, when he talked to Luke O'Day, he didn't mention anything about his equipment not working. And we also know, according to Chief Weber's testimony, that if your equipment is not working, you are required to do a pre-squad check to make sure all your stuff is working, all your equipment is working. And Mensah didn't report that his recordings didn't work. We know with that, if there's any equipment that doesn't work, you're supposed to put it on a whiteboard at the Wauwatosa Police Department. That did not happen. We know that if you discover that your equipment doesn't work when you're out on the street, that you're then supposed to fill out a form when you come back on your shift. And we know that Mensah didn't do that either. He didn't do any of those things because his equipment was working just fine. His squad camera was working fine. His audio video recording was working just fine. He just chose not to follow his training and to do that. There's several things that Mensah also doesn't remember. He doesn't remember that the gun on the passenger seat didn't have an extended magazine. He claims there was an extended magazine to Luke O'Day, but that was a lie. He didn't know what time the park closed when he was talking to Luke O'Day at first, but towards the end of the conversation, then he said, oh, the park did close. He didn't know whether or not he illuminated the inside of the car with his flashlight. He says the details are hazy. He didn't know when he unholstered his gun. He didn't know if Jay ever even took possession of his weapon. This is what he told Luke O'Day. We know that collectively, the totality of the circumstance that we have talked to 6 different people in law enforcement. We talked to Chief Weber, Lieutenant Roy, William Harmony, Pamela Holmes, Ricky Burns, and James Trano. Collectively, they all represent 179 years in law enforcement. And collectively, they have only fired their weapon twice with 0 fatalities among our numerous witnesses. But Chief Weber actually sat up here and said he doesn't know if it's an anomaly, whether or not firing your weapon within a 4.5 time period, 19 times, killing 3 people. He can't say that that's an anomaly, but he doesn't know anybody that's ever done that. We know that in light of the Alvin Cole shooting, that for that shooting, Mensah was on the scene for less than 30 seconds and he fired his weapon. He was the only officer that fired his weapon in that situation. That happened in February 2020. We know with the Antonio Gonzalez shooting that he turned his camera off on the way to Antonio Gonzalez and that his partner was there for 3 minutes, his partner who was senior to him, and Mensah was there for 1 minute and he fired his weapon. We heard from Ricky Burns and James Trano how homicide is supposed to be. We believe that we have presented evidence that from various officers that this was about justification, not an investigation. So we're very thankful to the court, to the clerk, to the court reporters, to the deputies to give us this opportunity to present this. Because Joseph Mensah has been able to shape this narrative in that 47 minutes unrecorded conversation that occurred in June 23rd, 2016. We believe that he shaped the narrative. We have given to the court what we believe has happened, and that Jay Anderson is the most important witness in the situation. The silence, the evidence speaks volumes. We believe that there is probable cause to charge Joseph Mensah with second-degree reckless homicide. We believe that there's probable cause to charge Joseph Mensah with homicide by negligent handling of a dangerous weapon. We believe that there's more than probable cause that we've demonstrated to the court. And we've used our 47 minutes to clear the record. Thank you.
All right, okay. We got a couple follow-up questions. Exhibit 22, is that the audio of the interview, or is that the transcript?
That's a transcript.
Okay. We have all the exhibits then?
Yes, Your Honor. I'd ask to move into evidence Exhibit 95, which is the PowerPoint that we gave today.
All right, the court will receive 95. I don't recall, did you also submit the transcript of the Skupic deposition?
With Chief Weber, yes, it's Exhibit 1.
Okay. Okay, thank you for your work on this, and I believe we've agreed on a date here for decision. What is it again, 25th?
June 25 at 9 a.m.
June 25 at 9 a.m. I anticipate that being in room G55 of the Criminal Justice Facility, which is on the G level. It's basically the second floor. So you're welcome to attend, and if we will broadcast that or live stream that, and I suppose we will still be subject to certain physical distancing in there, so you should probably arrive early if you want to get a seat. I don't believe there's going to be any overflow viewing anywhere, so it'll either be in the courtroom or it'll be on the live stream. Anything further today?
No, thank you, Your Honor.
All right, thank you.
Thank you. Or should I just, let me just.
Yes, that's preferred.
Okay.
Yes. Thank you. Yep.
Yeah, I think, yes, thank you.
All right, so that is going to conclude the closing argument. So I'm going to end the stream here. For those of you that are interested and want a sneak peek at some open records that we received, I'm going to start another stream and we'll go through some stuff. That stream I'm not going to save. So whoever jumps on, and it's a little sneak peek. So I'll see you guys then.